Hi, I'm Philip Hundl, and I'd like to talk to you today about mediating a land litigation case. Uh, I'm a mediator. I represent, well, I'm an attorney and mediator, and I represent lots of clients in land litigation, and that has, over time, translated into uh, having an interest in helping folks mediate these type of cases. And so, and that a big reason is, well, I've in almost all 90, I'd say 99% of our land litigation cases, be it partition cases, condemnation related cases, easement dispute cases, uh, we ultimately, or at some point in the litigation, will go to mediation. And so I've found mediation to be extremely helpful. So therefore, I started mediating these cases and being a mediator. And so um, that's what I want to talk. Sometimes people will say, "Well, why mediate? Why waste time mediating? What are the reasons or what's the benefits of mediating a case?" And this can be in general with almost all litigation, be it family law, be it just a civil breach of contract litigation case. But I'll talk specifically about land litigation and probably more on point partitions or easement dispute cases. Um, First, most courts will require you at some point before having a trial to go to mediation. And so, if that's going to be the case, I typically say, well, really sometimes the sooner the better to go to mediation so that you don't spend more time and money in the litigation process. So, the sooner you can go to mediation, probably the better. Now, I'll be the first one to say it's important that in mediation, and I've done some top 10 pointers of being as a lawyer being ready to go to mediation. And so um, one of the things you don't want to do is go to mediation empty-handed or with a lack of knowledge or understanding of the facts of the case, the facts of the ownership interest of the properties. And so for example, so you want to go to mediation sooner rather than later, but you want to have enough information when you go to mediation to be informed and to be able to make decisions. So number one, first, let's just call it the top five reasons to mediate a land litigation case is most courts will require you anyway. Number two, by going to mediation, um, you you gain or retain control of the outcome of the case. The parties have the opportunity at mediation. Remember, this is mediation and not arbitration. And I've talked about what arbitration is. The mediator at a mediation is going to try to facilitate uh, a resolution of the dispute amongst the parties. But it's something that you as a you know a party in the litigation case is going to have to agree to the outcome, right, or the resolution. It's not going to be a decision made by the mediator, and that's just how it is. So you retain control of the outcome, and in land litigation cases, unlike just simple uh, monetary disputes of just so one party wants to pay $10,000 and one party wants to receive $100,000 and just trying to fight over how much money and trying to get closer and closer together on the money aspect. With land litigation, there's a lot of moving parts, especially in a partition case, where uh, there may be multiple tracts of land, various parties, in deciding which party receives which land. It's almost like puzzle pieces, and you're playing with puzzle pieces of what everyone can agree to, and then also different ways to divide up land. Even if you have, let's just say, in a partition case, several tracts of land, and you think, well, those tracts of land are well defined. Well, in a mediation, you may end up dividing up one of those tracts of land. We've had partitions where, for or partition mediations. So in mediation, we may have 2 hours of time working on the dividing line of the whole tract into two pieces, and how much once again how much acreage each party is going to get. So retaining control, we can build in lots, and retaining control of the outcome. Um, for example, I mean, you could, if certain parties, in an easement dispute over a road, say one party agrees that they'll build a road, and one party is going to contribute a certain amount of money to build the road, so that the one party has his own road and they're not using the same road. Well, you may build in time frames so that it's doable for everyone to get the road built, and it doesn't have to happen immediately. So um, another big advantage and the reason why you'd want to go to mediation is we talked about cost. So the cost to litigate a case through trial, be it a bench trial with a judge or a jury trial, is extremely expensive. And yes, there are definitely cases where parties are willing to do that and spend that kind of money on a litigation to have a final outcome. And I say a final outcome, at the trial level, of course, a party can always appeal that outcome, but by going to mediation, it's a good way to limit the litigation cost. Of course, if you reach a resolution. Without a doubt, if you go to mediation and you don't reach a resolution, you're continuing to have to litigate, then obviously you didn't reduce your litigation costs because you had to go to mediation. I understand that, and mediators understand that, but the success rate at resolving cases at mediation or shortly thereafter is very high. So it is cost effective to take a case and get a case to mediation. Once again, sooner rather than later. What you really don't want to do is have sunk, a party does not want to have to sink a lot of litigation expenses into a case, be it attorney's fees, deposition costs, other expert expenses, to feel like, well, it's too late. If I've gone this far, we might as well have a trial, as opposed to giving mediation a chance. And then another top reason to go to mediation is it really keeps things more private, more confidential, as opposed to a trial. A trial is going to be a public, and what the outcome of the trial will be public. Will be open to the public. So if you want to keep things more private, then reaching a confidential settlement agreement, or if the parties agree to have it confidential, is something that you want to do. And then the time frame and timetable, it varies. Different courts have faster dockets to get to trial than other courts, but it's very possible that a case could take between 1.5 to 3.5 years to get to trial. I know that sounds like a long time, but given the different events that we've had over the last couple of years, or last year especially, courts have definitely cases have been rescheduled, trials have been canceled. So if you want a speedier time frame of resolution to your case, getting it to a meaningful mediation is going to definitely speed up the possible route, or at least the chance of resolution of your case. So with that, I hope that's helpful. We talked about top 5, top 6 things, reasons that to mediate a case, specifically a land litigation case. Once again, my name is Philip Hundl. My legal practice is land litigation as an attorney for parties and also as a mediator. So if you have any questions about mediation, happy to visit with you about that. And then also on this, I've been told to click like and subscribe to this YouTube channel if this content's been helpful for you. Thanks.